What happens to jointly owned property upon the death of one owner? Well, the answer to that question is it depends. It depends on what type of property it is and how it's titled. So, if we're talking about a joint bank account, for example, usually those bank accounts are payable on death to the survivor. So, if we have something like that in place that's joint asset, then it's not going to go through probate. No matter what you put in your will and who you want it to go to in your will, it's not going to go through probate. It's going to go to the survivor of the joint account. If we have a house, for example, that's a case where it's going to depend on how it is titled. If it is titled so that it is you two are joint with rights of survivorship, then it will be treated similarly to the bank account where it will go to the survivor. It's not going to go through probate. It will immediately go to the survivor of the two. But if you are just joint tenants, you don't have rights of survivorship, you may have a joint property that still ends up going through probate, and your half of this house or this land is going to be probated in accordance with your will or in accordance with the laws of intestacy if you do not have an estate plan. So very important that even if you have joint property, that you ensure that it is properly titled if your goal is to avoid probate in having this joint asset.